Hello everyone, I am going to ask some questions from the criminal law. I will ask that questions from the BNS as well as the Indian Penal Code. Okay. So first question from my side is causing death of a child in a mother's womb. There are four options. Number one is always homicide. Number two, with intent to cause miscarriage is homicide. Number three is culpable homicide. And number four is culpable homicide if any part of such child has been brought forth. Which option is correct? My reply is answer 4. Okay. Next question is a digs a pit and leaves for deadly and poisonous snake into it with intention to causing death to the others. B falls in pit and bitten by the snake. A is guilty of which offence? Culpable homicide not amounting to murder. According to section 100 of the BNS, voluntarily causing grievous hurt, murder. According to section 101, no offence. Answer is A, culpable homicide not amounting to murder, which is mentioned in section 100 previously in IPC, that is section 299. Okay. A has consensual sexual relation with J's wife. C gives to X a valuable property which belongs to the X. Okay. Which belongs to the Z. What kind of offence committed by the wife and the paramour of that wife? Criminal breach of trust, theft, criminal misappropriation property, and theft and criminal misappropriation. The right answer is B, criminal, that is the theft. The next question is, the right of private defense is a preventive right, not a punitive right. This is the case in which is the case, delete कर देना, काट देना, अभी रहने दो, वो काट लेगा, ठीक है. The right of private defense is a preventive right, not a punitive right. It was held in which case? Number one, Amjad Khan versus state, Vishwanath versus state of UP, Devanarayan versus state of UP, and state of UP versus Ram Sarup. Devanarayan versus state of UP is the right answer. In this case, Apex Court held that right of private defense is a preventive right, not a punitive right. Okay. Next question is, who is known as father of the IPC? Who is known as the father of the IPC? My reply is Sir James Fitzgerald Stephen, Sir Lord Thomas James Babington Macaulay, Sir Thomas James Babington Macaulay. That is the answer D. Okay. The next question is, crime is an committed or omitted in a violation of public law, either forbidding or commanding it. This is the definition of crime given by which jurist? Number 1, Stephen. Number 2, Blackstone. Number 3, Kenny. Number 4, Austin. Answer is Blackstone. This is the question which is very important for the judicial service examination, especially for UP. The next question is, what are the essential ingredients of the nullum crimen sine lege, nulla poena sine lege? This is the Latin maxim. What is the meaning of this maxim? Number 1, retroactivity of the penal laws. Number 2, penal statute must be constituted strictly. Number 3, certainty in the legislation. Number 4, accessibility in the of the law. Which is not a correct answer? Answer is A. That is the retroactivity of the penal laws. Okay. The next question is, which of the following case Lord Sumner said, they also serve who stand and wait? Answer is Indus River case. Number 2, Sankritola post office case. Number 3, J.M. Desai versus state of Bombay case. Number 4, Gurdat Mal versus state of UP. Answer is Sankritola post office case. Okay. Next question, which of the following case is related to marital rape? Number 1, Independent Thought versus Union of India, Syama Bano versus Saira Bano versus Union of India, Nautej Johar versus Union of India, and K.S. Putta Swami retired and another versus Union of India. The answer is Independent Thought versus Union of India. The next question is, section 377 has been partly declared unconstitutional in which case? Number 1, Independent Thought versus Union of India, Saira Banu versus Union of India, Navtesh Singh Johar versus Union of India, Justice K.S. Puttaswamy versus Union of India. Answer is Navtesh Singh Johar versus Union of India. In this case, section 377 has partly declared unconstitutional. Okay. The next question is which of the case apex court observed that there is a distinction between taking or allowing a minor to accompany a person. This is very important case. Number 1, Vishwanath versus State of UP. Number 2, State of Haryana versus Rajaram. T.D. Vadgamma versus State of Gujarat. And S. Vardarajan versus State of Madras. Answer is D. S. Vardarajan versus State of Madras. In this case, court held that there is a difference between taking a person and allowing a person to accompany it. Okay. Next question is, which section of the BNS is related to the rape? Number 1, section 63. Number 2, section 57. Number 4, 100. Number 3, 100. Number 4, 101. Answer is section 63. Section 63 of the BNS defines the rape. Okay. The next question is, the statement in every statute mens rea is to be implied unless contrary is shown. This is the question which asked several times in the different states in judicial service examination. Who said this, or in which case it was held? Number 1, option, your option is Fowler versus Paget, Lord Kenyon, Serras versus Dudgeon, Justice Wright, Brand versus Wood, Justice Goddard, and R versus Prince, Justice Blackburn. This is the case, Serras versus Dudgeon, in which Justice Wright held that in every statute mens rea is to be implied unless contrary is shown. Okay. This is very important. The next question is doctrine of joint liability as envisaged in section 3 subsection 5 of the BNS Bharatiya Nyaya Sanhita is based on the decision of Barind Kumar Ghosh versus Emperor, Macaulay versus R, Pandurang versus State of Hyderabad, R versus Cruz. The answer is 4, R versus Cruz. In this case, apex court, court held that what is the principle of joint liability, okay, on which section 34 of the IPC is based. Now section 34 is embodied in section 3 subsection 5 of the BNS. Okay.